How's it going, everyone? This is icy.prosperity. If you've come across this YouTube channel, then this is all things wealth, success, learning, education. Today's topic is going to be credit, specifically Fair Debt Collection Practices Act, the FDCPA. The importance of the FDCPA is to know your rights as a consumer when it comes to debt collection and the responsibilities of the debt collection agencies. If you know those two things, then you are in control of your consumer report in that area. And if you know these laws, you know your rights and their responsibilities, you're able to delete collections from your consumer report, which will in turn boost your credit score. It's also important to understand these practices because they're here to protect us. On top of that, if you do take this a step further and you exercise your rights, you can gain compensation from this. In this episode, we're going to be reading through this article we have here, which is actually the Consumer Compliance Examination Manual from September 2023. This is what seems to be the latest publication that I could find with pertinent information to the FDCPA. This will talk about Regulation F, which was implemented in 2021, amended in 2021. It will talk about the Dodd-Frank Act. The purpose of this really is it's a read-through so that you can listen to this over and over again and get the language into your mind so that when you're writing your letters, your dispute letters, you'll know what to write, what language to write. I'm not going to be implementing any of my own opinions into this. We're just going to read straight through. So let's get started. Before we do, we are going to be reading through this article here as well as the actual FDCPA, the Fair Debt Collection Practices Act, which the FTC has provided the PDF version. And for that PDF version, it was last amended in 2010. So the two important acts that we have, well, the one important regulation, the Regulation F, the amendment, and then the Dodd-Frank Act, which we'll talk about. Those two are important and pertinent updates to the FDCPA. All right, so let's get into it. We're starting off with the FDIC, Consumer Compliance Examination Manual, September 2023. All right, we have here unfair, deceptive, and abusive practices, FDCPA, Fair Debt Collection Practices Act. Introduction. The Fair Debt Collection Practices Act, FDCPA, 15 USC 1692 et seq., which became effective March 20th, 1978, was designed to eliminate abusive, deceptive, and unfair debt collection practices. The FDCPA also protects reputable debt collectors from unfair competition and encourages state action to protect consumers from abuses in debt collection. The Dodd-Frank Wall Street Reform and Consumer Protection Act, Dodd-Frank Act, granted rulemaking authority under the FDCPA to the Consumer Financial Protection Bureau, CFPB, and with respect to entities under its jurisdiction, granted authority to the CFPB to enforce compliance with the FDCPA. The federal banking agencies, the National Credit Union Administration, the Federal Trade Commission, and certain other regulators are authorized to enforce compliance with the FDCPA with respect to institutions under their respective jurisdictions. When the FDCPA became effective, it authorized the FTC to issue rules only for states to apply for exemptions from the requirements of the FDCPA. The FTC issued Regulation F to govern this process. The Dodd-Frank Act transferred authority for Regulation F to the CFPB and authorized the CFPB to issue substantive rules under the FDCPA with respect to the collection of debts by debt collectors. The CFPB restated the FTC's Regulation F in 2011. In 2020 and 2021, the CFPB amended Regulation F. The amendments, which address a broader range of topics such as debt collection, communications, and restate the substantive provisions of the FDCPA, became effective on November 30th, 2021. The CFPB has issued frequently asked questions, a small entity compliance guide, and other reference materials related to the FDCPA and Regulation F. Definitions: 12 CFR 1006.2. Debt that is covered. The FDCPA and Regulation F apply only to the collection of debt incurred by a consumer primarily for personal, familial, or household purposes. They do not apply to the collection of corporate debt or to debt owed for business or agricultural purposes. Debt collectors that are covered. Under the FDCPA and Regulation F, a debt collector is defined as any person who uses any instrumentality of interstate commerce or mail in any business whose principal purpose is debt collection. Any person who regularly collects or attempts to collect debts owed to another person. A creditor who, in the process of collecting its own debts, uses a name other than the creditor's own, which would indicate that a third person is collecting the debt. For purposes of 12 CFR 1006.22e, only a person who uses any instrumentality of interstate commerce or mail in any business whose principal purpose is the enforcement of security interests. Debt collectors that are not covered. A person is not a debt collector under the FDCPA and Regulation F when the person collects another's debt in isolated instances, debts under the person's own name that the person originated, debts that the person originated and then sold but continues to service, for example, mortgage and student loans, debts owed or due, or asserted to be owed or due to another that were not in default when they were obtained, debts that were obtained as security for a commercial credit transaction, for example, accounts receivable financing, debts incidental to a bona fide fiduciary relationship or escrow arrangement, for example, a debt held in the institution's trust department or mortgage loan escrow for taxes and insurance, debts for another person who is related by common ownership or corporate control. Others that are not covered also include officers or employees of a creditor who collect debts owed to the creditor in the creditor's name, legal process servers. Examples. The following examples illustrate the definition of debt collector. An institution's principal business purpose is the collection of debts. The institution is a debt collector, assuming it uses any instrumentality of interstate commerce or mail. An institution regularly collects debts owed or due to another. The institution is a debt collector. An institution services loans owned by others. The loans placed for servicing regularly include loans that are in default when placed with the institution. The institution is a debt collector as to any debts that were in default at placement. An institution's principal business purpose is the collection of debts it has purchased. The institution is a debt collector both when it contacts consumers itself and when it hires other collection agencies to do so, assuming it uses any instrumentality of interstate commerce or mail. An institution collects defaulted debts that the institution has purchased but does not collect or attempt to collect directly or indirectly debts owed or due or asserted to be owed or due to another, and does not have a business the principal purpose of which is the collection of debts. The institution is not a debt collector. An institution originates loans. When any of its loans go in default, the institution attempts to collect them while using an assumed name. The name indicates that the third party is collecting the debt. The institution is a debt collector. An institution's principal business purpose is the enforcement of security interests. The institution is a debt collector for purposes of 12 CFR 1006.22E, assuming it uses any instrumentality of interstate commerce or mail. 12 CFR 1006.22E prohibits taking or threatening to take any non-judicial action in certain circumstances, such as where there is no present right to possession through an enforceable security interest. Communications. Communicate or communication as defined in 12 CFR 1006.2D means the conveying of information regarding a debt directly or indirectly to any person through any medium. If an attempt to contact, a message to, or a discussion with a consumer or third party does not convey information regarding a debt, it is not a communication under Regulation F. Even if such actions are not communications, they may be attempts to communicate for the purposes of the FDCPA and Regulation F. An attempt to communicate is any act to initiate a communication or other contact about a debt with any person through any medium, including by soliciting a response from such person. For example, placing a telephone call to a person is an attempt to communicate with the person, regardless of whether the collector reaches the person. A voicemail with the content described in 12 CFR 1006.2J is a limited content message. A limited content message is not a communication for the purposes of the FDCPA and Regulation F. However, it is an attempt to communicate. Communications in connection with debt collection. 12 CFR 1006.6 and 1006.10. When, where, and with whom communication is permitted. Communicating with the consumer. Any debt collector may not communicate or attempt to communicate with a consumer at any unusual time or place, or at any time or place that the debt collector knows or should know that is inconvenient to the consumer, unless the consumer has given prior consent for such contacts directly to the debt collector, or a court of competent jurisdiction has already given permission for such contacts. A debt collector may not communicate or attempt to communicate with a consumer at the consumer's place of employment if the collector knows or has reason to know that the employer prohibits such contacts. A debt collector knows or should know that a time or place is inconvenient for a consumer if the consumer uses the word inconvenient, or if the facts and circumstances indicate that a time or place is inconvenient for the consumer, even if the consumer does not specifically state to the debt collector that a time or place is inconvenient. Absent information to the contrary, debt collectors are to assume that communications and attempts to communicate between 9 p.m. and 8 a.m. in the consumer's time zone are inconvenient. If a debt collector knows that the consumer has retained an attorney to handle the debt, and knows or can readily obtain the attorney's name and address, the debt collector may not communicate or attempt to communicate with the consumer unless the attorney is unresponsive or agrees to allow direct communication with the consumer. Ceasing communication with the consumer. When a consumer refuses in writing or electronically to pay a debt or requests that the debt collector cease further communication, the collector must cease all further communication and attempts to communicate with the consumer with respect to that debt, except to advise the consumer that the collection effort is being stopped. Certain specified remedies ordinarily invoked may be pursued, or, if applicable, that a specific remedy will be pursued. Cease communication requests sent by the consumer in writing or electronically are complete when they are received by the debt collector. Communicating with third parties. In general, a debt collector who is trying to collect a debt may communicate with only the following persons: the consumer, the consumer's attorney, a consumer reporting agency, if permitted by local law, the creditor, the creditor's attorney, the debt collector's attorney. The consumer or a court of competent jurisdiction may, however, give the debt collector specific permissions to communicate with other third parties. For purposes of this restriction, the term consumer is defined to include the consumer's spouse, parent, if the consumer is a minor, guardian, executor, administrator, or successor in interest. A debt collector who has not yet located a consumer may ask a third party for the consumer's home address, telephone number, and place of employment, location information. The debt collector must give the collector's own name and state that the collector is confirming or correcting location information about the consumer. Unless specifically asked, the debt collector may not name the collection firm or agency. The debt collector must not state the consumer owes any debt. The prohibition against engaging any person in telephone conversations repeatedly or continuously with intent to annoy, abuse, or harass, discussed below, applies to calls to third parties. Additionally, a debt collector may not communicate with a third party more than once unless the collector believes that the information from the earlier communication was wrong or incomplete and that the third party has since received better information, or unless requested to do so by the third party. Bona fide error in electronic communications with third parties. A debt collector's prohibited communication with a third party by email or text message can be a bona fide error for purposes of civil liability under 15 U.S.C. 1692 K.C. if the debt collector maintains procedures reasonably adapted to prevent such communications. The procedures are reasonably adapted to this purpose. For example, if they contain the steps outlined in 12 CFR 1006.6 D3 through 5. Right to opt out of electronic communications. When communicating or attempting to communicate using a specific email address, telephone number for text messages, or other electronic medium address, a debt collector must provide the consumer an opt-out notice. The notice must be clear and conspicuous and must describe a reasonable and simple method by which the consumer can opt out of further electronic communications or attempts to communicate by the debt collector to that address or telephone number. Prohibited practices: harassing, oppressive, or abusive conduct. 12 CFR 1006.14. A debt collector may not engage in any conduct the natural consequence of which is to harass, oppress, or abuse any person in connection with the collection of a debt. For example, a debt collector may not use or threaten to use violence or other criminal means to harm the physical person, reputation, or property of any person. Use obscene, profane, or other language that abuses the hearer or reader. Publish a list of consumers who allegedly refuse to pay debts, except to a consumer reporting agency or to persons meeting the requirements of sections 603F or 604A3 of the Fair Credit Reporting Act. Advertise a debt for sale to coerce payment. Make telephone calls without meaningfully disclosing the debt collector's identity, except as allowed to obtain location information. Communicate or attempt to communicate with a person through a medium of communication if the person has requested that the debt collector not use that medium to communicate with the person, with certain limited exceptions. Telephone call frequency limitation. A debt collector may not cause a person's telephone to ring or engage any person in telephone conversation repeatedly or continuously with the intent to annoy, abuse, or harass. Compliance with this provision is presumed unless either of the following occurs, in which case a violation is presumed. The debt collector places telephone calls to a person in communication with the collection of a particular debt more than 7 times within a 7-day period. The debt collector places a telephone call to a person in connection with the collection of a particular debt within 7 days after engaging in a telephone conversation with the person about the particular debt. Telephone calls do not count toward these telephone call frequencies if they are placed with the person's consent given directly to the collector within the last 7 days. Not connected to a dialed number. A call does not connect to the dialed number if, for example, the collector receives a busy signal or an indication that the number is not in service. Comment 14B3 II through 1. Placed to the consumer's attorney, a consumer reporting agency, the creditor or creditor's attorney, or the debt collector's attorney. In the case of student loan debts, the term particular debt means all student loan debts that a consumer owes or allegedly owes that were serviced under a single account number at the time the debts were obtained by a collector. False, deceptive, or misleading representations or means. 12 CFR 1006.18. A debt collector may not use any false, deceptive, or misleading representation or means to collect or attempt to collect a debt. For example, a debt collector may not falsely represent or imply that the debt collector is vouched for, bonded by, or affiliated with the United States or any state including the use of any badge, uniform, or similar identification, falsely represent the character, amount, or legal status of the debt or of any services rendered or compensation the collector may receive for collecting the debt, falsely represent or imply that the collector is an attorney or that communications are from an attorney, threaten to take any action that cannot legally be taken or that is not intended to be taken, falsely represent or imply that non-payment of any debt will result in the arrest or imprisonment of any person or the seizure, garnishment, attachment, or sale of any property or wages of any person unless such action is lawful and intended by the debt collector or creditor. Falsely represent or imply that the sale, referral, or other transfer of the debt will cause the consumer to lose a claim or a defense to payment or become subject to any practice prohibited by the FDCPA or Regulation F. Falsely represent or imply that the consumer committed a crime or other conduct to disgrace the consumer, conduct or threaten to communicate credit information that the debt collector knows or should know to be false, including not identifying disputed debts as such. Use or distribute written communications made to look like or falsely represent to be documents authorized, issued, or approved by another court, official, or agency of the United States or any state, or that give a false impression of their source, authorization, or approval. Use any false representation or deceptive means to collect or attempt to collect a debt or to obtain information about a consumer. Fail to disclose in the initial written communication with the consumer and in the initial oral communication, if it precedes the initial written communication, that the debt collector is attempting to collect a debt and that any information obtained will be used for that purpose. In addition, the debt collector must disclose in subsequent communications that the communication is from a debt collector. These disclosures do not apply to a formal pleading made in connection with a legal action. Falsely represent or imply that accounts have been sold to innocent purchasers. Falsely represent or imply that documents are legal process. Use any name other than the true name of the debt collector's business, company, or organization. A debt collector's employee may use an assumed name when communicating or attempting to communicate with a person, provided that the employee uses the assumed name consistently and that the debt collector can readily identify if any employee using an assumed name. Falsely represent or imply that documents are not legal process or do not require action by the consumer. Falsely represent or imply that the debt collector operates or is employed by a consumer reporting agency. So that's where we're going to stop for tonight. We made it a good amount of ways. Go ahead and rewatch that for now. It's good information. Some of the most important. Once we're finished with this, we'll have a good ground and you'll understand the actual FDCPA a whole lot better already. Thanks again for watching. I hope you like and subscribe to keep the channel going. This is Icy Prosperity, and I'll see you in the next video.